Welcome to this policy exchange fringe event on human rights. My first duty is to apologise on behalf of John Rentoul from The Independent, who was due to chair, but unfortunately is not able to. So that leaves me with the role of chairing today's event, and I'm Blair Gibbs. I'm the head of crime and justice at Policy Exchange. A number of you here have a long-standing interest in human rights, and you'll be aware that Policy Exchange in February this year published Bringing Rights Back Home. In that publication we tried to suggest a way forward from the current situation, the current status quo, which we thought was in danger of undermining human rights and public support for human rights. We warned of a growing conflict between politicians and judges, the spread of human rights into inappropriate areas, criticised the conduct of the European Court in Strasbourg in some cases, and questioned the selection process of Strasbourg justices. We argued that the UK perhaps needed a new human rights settlement where Parliament's role was properly respected and our own Supreme Court was the usual place where claims on human rights were settled, with perhaps a much smaller role for Strasbourg in the future. Lord Hoffman, who wrote a foreword to the report, supported much of that analysis. And I think today's event is very timely, not least because human rights continues to be a subject of intense media interest, but also, of course, because of the recent announcement by the Home Secretary just a short time ago today about the changes that the government is planning on Article 8 rules around immigration and deportation. Since the coalition came to power, human rights, predictably, have been one of the most controversial issues in the Home Affairs agenda, whether it's prisoners voting, sex offender registration, deportation of terrorists. I think they've all called into question the view that individuals in politics have about the right place for judges and the right role for Parliament. To discuss all of this, and hopefully some very good contributions from the floor, we have two of what I would call the two sort of leading conservative thinkers on human rights issues. To my left, Dominic Raab is Conservative MP for Esher and Waltham, former Chief of Staff to the Shadow Home Secretary, Foreign Office lawyer, and author of What Went Wrong with Rights. And I think he was the first to coin the phrase rights contagion. And to my right is the Attorney General, Dominic Grieve, who's MP for Beaconsfield, and obviously sits as the government's most senior legal advisor and, of course, the Shadow Justice role in opposition. As is usual, I'll ask each speaker to start for 10 minutes, beginning with Dominic to my left, and then we'll open up the floor to questions. Thank you. Dominic.
Well, thank you, first of all, to Policy Exchange for hosting this event. You've got your timing spot on, as ever, and for your well done, congratulations on your report Bringing Rights Back Home, which is an excellent analysis of the situation. And thanks also for the suitably provocative title to this fringe, which is it time for a new human rights settlement? And when Blair sent the title through, I sort of thought, yes, absolutely, everything must change in a peak of Boris Johnson-esque enthusiasm. And then I caught myself, and I thought about the Anglo-Saxon tradition of liberty. I thought about the words of John Locke, which are worth repeating. No one is permitted to take away or impair the life, liberty, health, limb, or goods of another. Or Thomas Jefferson's famous formula, the inalienable rights of life, liberty, and the pursuit of happiness. And so I asked myself, isn't it the essence of human rights, or at least our tradition in this country, that they're eternal, inalienable, and Lord Hoffman has used this phrase before, an irreducible shortlist of core freedoms from abuse by the state? That's certainly my understanding and what I grew up with as a young international lawyer, and I still hold the view today. I'm not saying, I want to be clear, that human rights are totally static, that their interpretation can never evolve. But if we're embracing a whole new human rights settlement, something has gone badly wrong. Because, at least in my view, human rights should not be like other areas of policy, whether they're school reforms, welfare policy, where the goalposts shift, if you like, because social mores shift. The empirical evidence, the amount of public money available shifts over time. That's the fluid ebb and flow of public policy and democratic politics, accountable to all of you at the ballot box. But not human rights. As I said, they're supposed to be immutable. That's the beauty of them. That's what we're protecting. Something intrinsic, something timeless, something immune to shifting political fads. And I think if we look at the Labour era, you'd expect me to say this, something did go badly wrong. Those supposedly timeless freedoms were junked with remarkable speed. We had ID cards, we had draconian proposals to extend pre-charge detention to longer than you've got in Zimbabwe or China, 1 million innocent people on the DNA database, children followed home from school by council snoopers to check whether they're eligible for the catchment area, even powers to enter your home to check the environmental credentials of fridges or the height of hedgerows. And all of this just strikes me as ludicrously authoritarian, none of it necessary to fight terrorism or crime, no trade-off, if you like, as we often heard, between liberty and security, just plain lose-lose. And I think the coalition's been a powerful force for good, dealt with ID cards, it's halved detention without charge, it's scaled back some of the surveillance powers, the Freedom Bill is going through the House as we speak, or will be when we get back. And I certainly want to pay tribute to the attorney who campaigned relentlessly in opposition to expose Labour's draconian instincts and is making sure we restore some of those lost liberties in government. I think it's not too high praise to say he's really one of the unsung heroes of this coalition, certainly in my view. Personally, I'd like to see the coalition go a bit further, especially on some of the things like extradition reform. We wait for Sir Scott Baker's report on extradition reform, which is expected shortly. Frankly, the fast-track extradition system under the European arrest warrant is abusive and arbitrary, and I hope we take that on head-on. But overall, I guess my message is when it comes to restoring our freedoms, our liberty, my cup is half full. The coalition has made good, solid progress. But that's only half the story. George Bernard Shaw famously said that liberty means responsibility, that is why he said most men dread it. And I think Labour's approach undermined both of these dimensions or aspects, liberty and responsibility. And rather than tackling the ongoing problem that has afflicted every administration since 1966 of judicial legislation from the European Court of Human Rights in Strasbourg, they imported it through the Human Rights Act. So whilst we lost some of our inalienable, immutable, eternable freedoms, we gained a bunch of increasingly expanded, newfangled novel rights, and many based, ultimately this is the direction of travel, on the creeping concept of economic and social rights. Very important to say, they are not in the European Convention, so the British government never signed up for them, Parliament never debated them, the taxpayer can't afford them, and the public don't want them. Like the right to prisoners, give prisoners the vote, decreed from Strasbourg, against the express terms of the European Convention and the protocol which it comes with, and the will of its architects. Anyone that wants to challenge this view, go back online. The negotiating history, the travaux préparatoires, are available online, so we know from the record, the negotiating record, this was never intended. So that's one example. Another example we're hearing a lot about today is the subtle, sort of surreptitious expansion of Article 8, the right to family life, which is really trying to stop people having their children taken away from them and scenarios like that. And the expansion is actually something we can't blame exclusively on Strasbourg. I put as a sort of Euro-realist or Euro-skeptic, however you want to phrase it, I think it's really important to understand that, because it's the result of judicial activism at home spurred on by the Human Rights Act. If anyone wants to challenge that, but just look at the data. Before 2000, when the Act came into force, we didn't have a single case of a criminal blocking a deportation order because it could undermine the Article 8 right to family life. Now there are 400 cases per year, and I pay tribute to the government for at least doing the transparent thing of releasing the data on this. And I've had a case with this scenario. A man killed my constituent, a young Nepalese waiter from Isha. The culprit was convicted of homicide. He's not married, he's got no dependents, but still we can't deport him because apparently it would disrupt his wider family ties. And you can just imagine what the victim's family think about that. And I want to make 2 points about this, 2 general points. First, these developments that we've seen, the judicial legislation, They defy the basic tenets of a democracy, which is strong rule of law, separation of powers, democratic accountability. Judges should rigorously interpret and apply human rights. That's the phrase in the European Convention. But they should not expand them or create novel rights. That's a legislative function. That's the job of MPs, accountable to you at the ballot box. The second point I want to make is in relation to prisoner voting, deportation. There are quite a few other areas where we've seen quite a lot of judicial activism. They've got very little to do with those inalienable, immutable, eternal freedoms that inspired the likes of Locke, Jefferson, the Anglo-Saxon tradition, if you like. It's not the inalienable right of a prisoner to vote when they temporarily forfeited their liberty after a fair trial leading to a criminal conviction. It's not an inalienable right to enter this country, it's a privilege. My father was a refugee, that's what he taught me. So of course we should be able to set some conditions or ask newcomers to undertake certain responsibilities. Just a few basic things like not robbing and killing people. So what can we do about this mess? Well, we can entrench our tradition of liberty, we can scale back some of these novel rights and restore some democratic accountability through a British Bill of Rights. And I worked with Dominic Grieve in opposition on some of the ideas about how we might do that. And in government, the coalition, as you all know, has set up a Bill of Rights Commission, and it can do important work. And in fact, I think it's already made some very sensible proposals about reforming the Strasbourg Court, particularly about the role of the Strasbourg Court as being a court of last resort in the most serious cases, rather than meddling in the sort of legislative function, which is what we see. And I think that, if I may say so, with members of the Fleet Street here, I think actually they were rather uncharitably reported across the media. I think if those reforms were taken up, actually they'd make quite a big difference. But more generally, if we're looking at the Human Rights Act, we've got to be realistic about this. We're in coalition, and there's no point in constantly banging on about the Lib Dems. And I think, from my point of view, it's pretty clear the Bill of Rights Commission is not going to come up with a detailed blueprint that both sides are going to agree on. I'm happy to be proved wrong, but I wouldn't bet the mortgage on it. And I think the best we can do, and already we're starting to see this, because the Bill of Rights Commission is issuing sort of reports and then almost like minority reports, so some of the publishing some of the wider opinions that are being expressed that they don't all agree on. So I think the best we can do is have clearly thought through options that inform the respective manifestos of each party going into the next election. Now, I want to be very clear about this. I'm not saying we can't make any progress. I think the Freedom Bill is going to be a terrific, make terrific progress on scaling back some of those draconian laws. The Home Office has been reviewing deportation and the right to family life, and of course we've had progress on that today from the Home Secretary. I think those areas, and that area, is low-hanging fruit. I entirely welcome what the Home Secretary said, although I think it will need primary legislation, not regulations, to work. But look, the substance of it and the recognition of the problem, yeah, it's very important. And of course, Britain chairs the Council of Europe for next month, which, so we've got this opportunity to drive some reform and drive these ideas that the Bill of Rights Commission has come up with for reforming the Strasbourg Court, which frankly ought to be spending far more time looking at systematic torture in Russia and Turkey, and less time trampling over the democratic prerogatives of a mature democracy and a mature parliament as we have in this country. So I think the coalition can make a difference. I think we can restore some of our freedoms. I think we can start the ball rolling on a Bill of Rights. But ultimately, it will, in my view, take a Conservative government to deliver the kind of human rights settlement that I think Blair and many others in this room, and myself included, would like to see.
Thank you, Dominic.
Well, thank you very much, and thank you for the opportunity from Policy Exchange to come and have a discussion on this issue, particularly on the back of the paper Bringing Rights Home, which was a very informed and rational contribution to a complicated debate. And one of the problems I think that we often have is that because of the complexity of the debate, and because actually it's often quite emotive at both ends of the spectrum, interestingly enough, rational considerations are sometimes very difficult to identify and come up with the rational solutions we need. Now, the problem I have, I suppose, in this assembly of the two Dominics is that not only do we have the same Christian name, but we did work together. He is my chief of staff for 18 months on the same topic. So I don't think there are many aspects of the policy direction and the issues that haven't been canvassed ad infinitum in the privacy of the staff room and my own office in the House of Commons when I was both Shadow Home Secretary and afterwards Shadow Justice Secretary, and indeed continue to take an interest in as Attorney General. So it won't come as a great surprise that large swathes of Dominic Raab's analysis are ones with which I largely agree. I think that perhaps my starting point is just to put a slightly different gloss on it, is this. I do start from the premise, and I said this last night at a Fringe, and I think it's worth repeating, that sometimes I get people coming along and saying to me, well, actually our human rights were very well protected by Magna Carta, habeas corpus, the Bill of Rights of 1689, and you know, why do we have anything else? And as I pointed out yesterday, Magna Carta, of course, contains some nuggets which are worthy of celebration. But it is worth pointing out that in the 16th and 17th century, you could shout Magna Carta as much as you liked, but if the Star Chamber had ordered your detention and torture in the Tower of London, it didn't actually serve very much help in preventing it, notwithstanding the fact that both detention without due process of law and torture were both banned, one by Magna Carta and the other by the common law. And as Dominic's rightly highlighted, nothing that we have ever had ever since has prevented the astonishing attack on our civil liberties that the last Labour government engaged in its sort of authoritarian post-9/11 frenzy, now thankfully being dealt with, I think, largely under the Protection of Freedoms Bill, of which I am very proud that we are actually doing this rather than just talking about it. Always difficult, more difficult to translate in government, doing what you promised in opposition, and perhaps your rhetoric, we may accuse your rhetoric carried you away. Actually, we're going to deliver it, and we're going to deliver it in full. I'm really delighted about it. So I suppose coming back to my theme is that I do happen to think that our rights need a framework of protection. And because we live in an environment where the state is infinitely more powerful and more intrusive than it was 150 years ago. Indeed, the growing power of the state is the major phenomenon of modern life. 100, 200 years ago, the state's power in this country, although they could hang you if you really transgress, but their ability to micromanage your life was very limited. Because of the development of the benevolent state, the welfare state, and the methods by which the state can acquire information on us, the state is now immensely powerful in relation to the individual, and it does require protection. And of course, it was in recognition of that post-Second World War that the European Convention was drawn up, and I suspect that Dominic and I will entirely agree that there isn't a single clause of the Convention that we would reasonably disagree with in terms of the aspirations and principles which are set out in it. The issue that has arisen is about its interpretation and its application through the Human Rights Act in our own national courts and its application at Strasbourg. And on those two topics, I just want to dwell a moment. But before I go to that, the other thing is the question of, is it a fixed or a dynamic document? That's a very difficult issue. It's quite clear that the European Convention has led to consequences which its enactors might not have reasonably envisaged. For example, at the time it was enacted, notwithstanding all the protections afforded in the Convention, homosexual practices, even carried out between consenting adults in private, were unlawful and criminal offences throughout most of Western Europe. Today, I would envisage that if any government were to attempt because Parliament suddenly had a strange sort of brainstorm to decide to criminalise homosexual practices between consenting adults in private, they would fall foul of a Human Rights Act challenge, and if they didn't fall foul of it here, they would fall foul of it before the European Court of Human Rights if an appeal were taken to Strasbourg. So I think that my perception is that the evolutionary nature of a document of this kind is almost inevitable, and I don't think we should necessarily be arguing that that is a bad thing, because I think if you start subjecting it to close scrutiny, one will realise that it is bound to reflect the norms of the societies in which it is placed. I know there have been arguments, for example, over the US Constitution that it should be strictly interpreted in lines with what was thought to be sort of current views in the late 18th century United States, and that it's not allowed to depart from that. I don't know about the US position, but I have to say that in the context of the Human Rights Act and the ECHR, I don't see that as being a reasonable way forward, and it would be rather strange, and I think it's quite contrary to all the jurisprudence that's emerged. Now, with that in mind, is it a perfect document, the ECHR? Well, I don't know about whether it's perfect in its drafting, but it is quite clear that there are serious flaws in the way it is being applied at a European level through the European Court of Human Rights. And that's a view not only shared by politicians like ourselves, it's one echoed by Lord Hoffman in his famous lecture to the Judicial Studies Board, and indeed reflected in his preface to Bringing Rights Home. Lady Justice Arden in her Thomas More lecture late in 2009, who made many of the same points, that here was a court that was set up with the intention of providing a sort of final framework, actually of adjudication, largely between nation states, which is in fact turned into a final court of appeal for a whole host and range of problems. Now, that's not entirely the court's fault. It's inherited a very difficult situation. There are new participating members of the Council of Europe from Eastern Europe who, frankly, whose track record on the rule of law is frankly pretty woeful. And they're getting hundreds of requests from people living in those countries for the court to interfere. If you go down into the registry of the court, where I went earlier this year, you can see the 150,000 case backlog that is slowly strangling the court and making it unable to do its work. The court knows, I think, as much as we know, that there is urgent need for reform. And that reform we have an opportunity of initiating during the British United Kingdom chairmanship of the Council of Europe, which is about to start in 2 months' time, and there is a government agenda to try to drive this forward by diplomacy and by lobbying. And my personal view is that we are likely to get quite a lot of support. Admittedly, it needs coordination between the 47 member states, but there's already the Interlaken process. The Secretary of State for Justice has been heavily involved in it. I've been involved in it. Other government ministers are going to play a part. And in fact, much of what we are trying to do is exactly the points that were set out in the policy exchange document in terms of the reform of the court, sifting out the applications, improving the quality of the judiciary, which is unfortunately extremely variable, and also exploring how we can find mechanisms by which we can ensure that the court does not turn into a micromanager and gives individual nation states the proper margin of appreciation. And on that theme, it is quite clear to me, and I've said it repeatedly, that I find that the decision of the European Court of Human Rights on prisoner voting, frankly, incomprehensible. The United Kingdom has a perfectly clear structure for dealing with human rights points. The matter was looked at every court level, up to the Supreme Court, and found that our way we deal with denying prisoners, convicted prisoners, the vote was perfectly compatible with convention rights. So to land themselves in the difficult position of having found against us on an issue which I think is pure micromanagement highlights to me that the court is not, I think, focusing correctly on what the key issues actually are. But part of its difficulty may well be that because it is having to do so much micromanagement in Eastern European countries, it thereby creates the sort of flow by which it then is micromanaging in countries where, in fact, everything is in place to ensure that convention rights are properly respected and observed. So that is an area that is going to be more difficult, but I personally think that by a process of dialogue we are likely to make good progress in this direction, partly because, as I say, my impression is that the court itself knows that it is going to have to change the way it approaches these issues. So that's one aspect, and in the brief time available, turning to the second, which is domestically. Yes, it's quite right. In the 18 months before we were elected to government, I spent a large part of my time working with Dominic on how we were going to have a British Bill of Rights. And in fact, by the time we'd finished the process, we had quite a reasonable blueprint, in my mind at any rate, and I think probably in the mind of those who'd been working on that commission, as to what we could do if we got elected. And it had the real prospects of, I think, creating something that would be better than the Human Rights Act, could protect some rights which enjoy no protection in the Human Rights Act at all, like the right to trial by jury, looking at administrative penalties without due process of law. And moreover, that in the process we could also look at some of the areas in which rights are interpreted. And that includes, and we've always been particularly focused on Article 8 and the right to private and family life. So I thought we had a package there which, whilst by no means finalised, offered a really good opportunity for taking forward if we got into majority government. But as Dominic rightly says, we have to face the fact we are not in a majority government, we are in a coalition government. And that presents challenges for government that we can't just ignore. If you don't have a majority for something in Parliament, you can't get it through. And the reasoning behind setting up the Bill of Rights Commission, the one set up under this coalition, of which some members who are on it are present in this room today, is to try to offer an opportunity to bring Liberal Democrats and Conservatives together to look at the possibilities of taking this forward. And interestingly, before the last election, it was clear to me there were at least some Liberal Democrats who were quite interested in the project. And that's what we're really going to have to wait and see what the Commission produces. Of course, at the same time as Conservatives, we can also look at the prospect of what we might do if we get elected to a majority government after 2015, and we can indeed offer that up. And at the same time, we can start looking at individual issues where, in fact, there is already, in my judgment, wriggle room within the European Convention, and where we can, in fact, carry out some changes. And of course, the Home Secretary has announced today one such area in terms of the way we deal with immigration cases, in order to try to minimise the exploitation of the right to a private and family life by individuals who are claiming that they can stay here, notwithstanding the fact that it's clearly in the public interest, the wider public interest, that they should be sent away. Of course, it's always going to be a balancing act, but a number of examples were cited today which suggest that the balance may be being exercised far too favourably in favour of the individual and not in favour of the wider society's rights as well. So that's really the package, and the pragmatic package, which I think we need to be continuing. And with Policy Exchange and other organisations feeding in their ideas, I think that we can make we can have a productive period of discussion about how we improve on the current situation. But I do look, just to end, to the reform of the court itself, and I think the reforms that are likely to come out of Strasbourg, that these may in fact start to have a knock-on effect also on our own domestic jurisprudence if we can achieve them. So these are interesting, thorny problems for government, but the fact that they exist is not a reason why they shouldn't be tackled. Thank you very much.
Okay, thank you very much, both of you. They were very good opening contributions. I'm just going to take Chairman's privilege and just begin by asking one question relating to what was mentioned, I think, by both, which is prisoners voting, which I know is one of the most controversial of these topics, but I think it actually demonstrated in recent times in the clearest way this conflict between Parliament, our own Parliament, and rulings from Strasbourg. There seems to be some uncertainty about where we go from here. As I understand it, the Council of Europe has agreed another extension. Parliament, as everyone's aware, voted and rejected the prospect of enfranchising convicted prisoners and would likely do so again. So have we reached a complete impasse? And if not, where do you think it's likely to go?
Shall I? I'm not sure we've reached a complete impasse, no. I mean, there's an Italian case called Scopola, I'm not sure how it's pronounced, which is coming before the European Court of Human Rights for consideration, which concerns prisoner voting rights, albeit in a rather different context. It's about deprivation of civic rights as a result of sentence, but which is certainly going to lead to the Grand Chamber re-examining the principles set out in Hurst and the other cases that have followed. And the United Kingdom has already requested and been given leave to intervene in that. And so we will have an opportunity when that comes on to be heard for our own representations to be made as to how the court should approach the matter. Although I do, in saying that, I'm not suggesting that suddenly as a result of that the problem is going to go away, but I think it may influence the decisions which the UK government then have to make. It's right to say that we have in our ministerial code very clearly set out the duty on United Kingdom governments to observe their international and national legal obligations, and that includes the Convention. And the Council of Ministers has given us 6 months from the Scopola decision, whenever it comes out, in order to come up with our proposals as to what we will do in the light of the Hurst judgment. It's worth pointing out that the Hurst judgment itself is very nebulous and doesn't in any way make clear what the UK government exactly needs to do to put things right, which is perhaps not necessarily a bad thing. It probably gives considerable leeway, although I think it rather indicates that the status quo is unlikely to be acceptable. But it's also worth pointing out that at the time of the Hurst judgment, the last Labour government, having buried its head in the sand about this issue, until we had the debate in Parliament, initiated partly by Dominic Raab and Jack Straw and David Davis, we never had an opportunity for Parliament to express its viewpoint, and it was in fact very helpful to have a free debate in Parliament with a vote at the end. And I think that that may be something that we're going to want to look at doing again when it becomes clearer what it is the court may be requesting of us. So, like all these things, I do see a dialogue taking place, so I don't actually think we are at the end of this particular road at all. And at the same time, that dialogue is, I think, feeding back to the court, the extent to which, it seemed pretty clear to me, there was very high levels of resistance and resentment at the way in which the court was seeking to micromanage a democratic parliament that believes, I think with some passion, that the rules that we currently have in this country are entirely compatible with the principles of the Convention.
But Dominic, do you think MPs would vote for anything other than the status quo if it ever came back to a parliamentary vote?
I'm not sure. I think if there was the possibility of, I don't know, a 1 year or a 4 year threshold, some of those who voted against might be picked off. But I think it's important to understand a couple of things. First of all, this is a classic example of something which come out of thin air from Strasbourg. If you read Article 3 of Protocol 1, which talks about free and fair elections, it says nothing about giving prisoners the vote. If you read the negotiating history to that protocol and that article, it's very clear, and by the way, as a matter of international law, that is relevant to the interpretation under the Vienna Convention. And it's very clear they talk about reserving discretion in cases of what they really had in mind was lunatics and felons. That's what they talked about. So it's clear the Convention never intended to enfranchise all or some prisoners. It was left at the discretion of states. Hurst in 2005, the case that the axe murderer that sued Britain, the court said, it's quite interesting, so the journey, the court said actually you can't have a blanket ban. Of course we never had a blanket ban, because if you're there on remand or a defaulter on your council tax or something like that, you wouldn't lose the right to vote. But nonetheless, they said it was the automaticity, it was the blanket ban. And now what's interesting about Scopola and Frodel is and this shows you what the court is doing, they're basically saying in both cases, they're saying really unless the sanction being applied to the prisoner or the criminal is relevant and related to the issue of forfeiting the right to vote, then you can't do it. And that really means that unless you're convicted of electoral fraud, you would be given the right to, you can't lose the right to vote. If that is upheld in Scopola, then there is, I think, very little room for a compromise deal that the House of Commons would accept. And I think, I certainly think Parliament would have the option and the opportunity to vote down, or should have the opportunity to vote down any proposals. And I think the government would then be in a position to go back to Strasbourg and say, well, look, you know, one of the big criticisms was that Parliament never debated it. Well, we debated it once, Parliament decided against. If we debated it again on concrete proposals and voted it down, I'm not sure there's, I'm not sure there's very much Strasbourg could do. There's no enforcement powers. We couldn't be fined. We're not going to be kicked out of the Council of Europe. The government could quite easily say, look, we tried our best, but we didn't. Parliament said no. And I think Strasbourg would be in quite an awkward position. They've picked a very awkward fight because they're creating a constitutional crisis where it's Strasbourg versus the elected lawmakers of a mature democracy. And so let's see whether they think again as Scopola. I suspect, knowing the judges and having worked on the Strasbourg court for a while, they will hold firm, in which case I think it's unlikely any compromise deal could get through the House.
Okay, very interesting. Right, we'll now open up to questions. Usual rules apply. Please say who you are and please finish with a question. Okay, gentleman here then. Andrew.
Well, do you agree with the Home Secretary that the Human Rights Act should be scrapped?
Well, it's been party policy to replace the Human Rights Act with the British Bill of Rights, and that is what we went into the last election with a manifesto commitment to do. And I'm completely comfortable with the possibility of replacing the Human Rights Act with the British Bill of Rights. I was arguing for it forcefully during the election campaign.
Okay, Andrew.
In classical conservative political theory, people opposed human rights.
Andrew Lillico, by the way. Yes.
Sorry, Andrew Lillico. In classical conservative political theory, the opposition to human rights was based on the thought that they were illiberal. For three kinds of reasons. First, because if you had a set of things which were permitted as opposed to a set of things that were forbidden, then if you hadn't thought of it, then if it wasn't on the permitted list, then it wasn't permitted. Whereas if it wasn't on the forbidden list, then it was still permitted. Secondly, because of that feature, lists of rights would tend to become too long. So they tend automatically to creep into the kinds of things which you were describing. And thirdly, because if the government thinks that it creates a right, the government will think it's entitled to vary it. And I believe that there's no coincidence at all that once Tony Blair starts believing that he creates the right not to be tortured, subsequently we've had all kinds of debates over under what conditions it would be okay to have evidence from people who are tortured or whether we should torture people. And yet, although that's the classical conservative set of objections to human rights, namely that they are fundamentally illiberal, most of the discussion about conservative objections to human rights were as if the objection were that we think that we want to be more illiberal than them, right? So we complain about not being able to, people talk about lack of ability to deport people or things of that sort. And so the question that I have is twofold. First of all, isn't some of the thoughts that you can, as it were, cure, that these are just a few minor problems, right? And if we can only sort them out, then that'll be okay, just misguided, because actually the kinds of problems you describe are a fundamental reflection of the whole concept of human rights. And secondly, how can we move the debate onto the ground where we focus on the fact that we oppose human rights because human rights rules, because they are illiberal, not because they're some kind of protection of liberty.
Okay, we'll start with those. Would you like to?
Yes, no, it's a great question. Gosh, I want to give a shortish answer. I think the common law presumption in favour of freedom basically operated that if it's not prohibited, it's allowed. That's obviously displaced by legislation. The problem is that the role of the state has grown massively under all administrations of all political hues since the dawn of the 20th century, certainly in the post-war period, and therefore that basic paradigm is just not the one we're working to anymore. And the real threat now, I think, comes from the state and not having at least some bedrock safeguards. So I think your analysis was certainly right. Whether it's correct today empirically, I'm not sure.
Yes, well, I think I agree with Dominic about this. I think that this sort of very, dare I say, sort of rather old-fashioned concept of the relationship between state and citizen and enshrined under common law, as I commented at my very start of my remarks, I don't think is viable, because you only have to look at the ease with which authority can violate individual rights, often in the name of expediency. And I mean, when we criticise some of the details of the operation of the Human Rights Act, it's also worth pointing out some areas where people might think that it's actually worked rather well. I mean, for example, separating elderly people, married couples, into separate care homes because of the administrative convenience of local authorities. That was stopped through a Human Rights Act claim. Requiring that elderly people should be lifted on hoists in care homes and that manual lifting should be dropped, which is a very demeaning process for the individual concerned, all done in the name of health and safety, and actually knocked on the head by a Human Rights Act claim. So I think it's worth remembering that for each case that we focus on and actually properly get troubled and exercised about in the Human Rights Act context, whether it's a Bill of Rights or Human Rights Act, doesn't really matter which it is, there are plenty of other examples of where the existence of a rights framework has proved to be a very powerful tool for the individual to assert common sense rights against bureaucracy. And bureaucracy can be tyrannical. We know this. I mean, it's something where I have, as Attorney General, with my responsibilities for the rule of law and the public interest, without giving away the great state secrets, the sorts of things which often come swinging towards one are about bureaucracies quite almost unintentionally trampling on individual rights in an improper way because it's administratively convenient to do it. And part of my role is actually to say, excuse me, you mustn't do that. And I hope I do it properly. But the fact that there's a rights framework behind that to help me is very valuable.
Okay, two questions over here, one there and then Joshua.
Robert Kay, I just wanted to suggest that one of the difficulties with the Human Rights Act, and one of the reasons why its supporters have gotten the people that they have, is that actually there was never any attempt to garner public support from the outset. It was very much a legal elitist project by people who had suspicion of the public, of the executive and the Parliament, who thought that the bureaucracies are essentially oppressive, that Parliament would never be strong enough to stand up for individual rights, and therefore the best protection was through legal and judicial measures. And actually one of the difficulties that you now have is it's impossible to sell human rights to the public because they were locked out of that initial stage. Actually, if you look at what's happened over the last 10 years, often it has been Parliament. Where it wasn't Parliament, it was a democratic electoral process which has stopped the intrusion into liberty that we've talked about here. It wasn't the Human Rights Act which stopped 90 days detention or 42 days detention, it was Parliament. It was the inability of the government to get that through its own backbenchers. ID cards were scrapped after electoral pledges by two parties. Actually, we can, by and large, rely on parliamentary democracy and the common sense of the British people to protect our liberties. If there is to be a new settlement, it needs to be one that carries the public with it, and the public needs to be engaged in that, the formulation of that settlement.
Well, I certainly agree. Sorry, going first. I certainly agree with you that the way in which the Human Rights Act was introduced was flawed. And indeed, in fairness to some of the people who supported the idea of a Bill of Rights or Human Rights Act, whichever it was, back in the early 1990s, they realised it was flawed as well at the time it was being done. It was done in a sort of brush it under the carpet, nothing very much is happening, rather than the then Labour government going out and really initiating a proper public debate. And I've no doubt it was done with typical new Labour sort of triangulation strategy, because this was an easy way of getting something onto the statute book, whilst avoiding difficult and awkward questions being asked. And we've paid a very considerable penalty for that, in the sense that there wasn't adequate debate at the time, and indeed really attempts at questioning. I was involved in the debates in Parliament. I was always rather under the sort of cosh of it being suggested that you were a Neanderthal who was failing to live up to the new realities, and that it was very disgraceful of you and called into mind that you might be a sort of reprobate individual if you were objecting to this wonderful concept. And there were all sorts of things which happened in it which bothered me. I mean, for example, I remember arguing very strenuously that the shortcut system of having an order making power to cure a declaration of incompatibility was a major erosion of parliamentary sovereignty and quite unnecessary, and was going to remove the critical debates that ought to be taking place between Parliament and the judiciary in those circumstances. And that was all gently brushed aside by Jack Straw, I remember. He may have been privately sympathetic, but he certainly wasn't going to sign up to that. And it was poorly implemented and sold afterwards, before it actually came in. So yes, if you're going to have this, I mean, one of the points that we were certainly was very much in my mind when we were working on our own Bill of Rights Commission, was that if we were going down this road of having a United Kingdom Bill of Rights, it was essential that we should go out and have a proper public debate.
Dominic, do you think from where we are now you can sell human rights to the public, or do you think the brand is
the brand is definitely undermined? And the polarised debate we now have on the Human Rights Act is interesting. You get, for some people, the tabloids, for example, think the HRA is responsible for everything. On the other hand, the NGOs say it's perfect and can't do anything wrong. And I'm an Isaiah Berlin liberal. I believe in negative liberty, i.e. the protection of individuals from the state, and rather than positive liberty, which he defines as giving them claims on the state. And the fact is that the Human Rights Act has shifted human rights from just protecting core civil liberties, core freedoms from abuse by the state, to creating positive duties and positive claims on the state. And the interesting thing is, 2007, the Ministry of Justice polled on this and surveyed, and they found, interestingly, in the sort of dog and duck responses they got back, exactly this dichotomy. People are very supportive of a law that protected their freedoms, defined in the way I've just explained. Where they got very negative responses was on positive claims on the state, particularly welfare, particularly immigration claims. So this very philosophical debate that frankly gets lost between the hurly-burly of the political sort of furore is actually reflected right from the abstract level through to ordinary people's opinions.
Joshua Rosenberg, yeah, can I take you back to the first question that you heard about the Home Secretary? Theresa May didn't say that she wanted to replace the Human Rights Act with a British Bill of Rights. She said, "I remain of the view that the Human Rights Act needs to go." So that does sound like a clear disagreement between the Home Secretary and the Attorney General.
No, I don't think so, Joshua. With great respect, the government's policy and the party's policy, coalition is slightly different because of the nature of the coalition. The party's policy has always been that we wish to repeal the Human Rights Act and replace it with the United Kingdom Bill of Rights. And I don't see anything in what the Home Secretary said which in any way differed from that position. I suppose that, as we're making the point, that we are in a situation in coalition where our ability to carry that out is dependent on the participation of our coalition partners. And to that extent, we are in a situation where at the moment, had we been in majority government, I have little doubt that we would already be some way down the road towards the enactment, consultation and publishing of a white paper for a United Kingdom Bill of Rights. So I have to say that I too asked the Home Secretary, but I took the Home Secretary's comments as being an indication that notwithstanding the interval that had followed since the last election, she was still of the view that she wished to see the Human Rights Act replaced. That didn't seem to me to be in any way a departure from what we've said previously.
All right, well, let me ask her the same kind of question, which is slightly less politically contentious and is more for information. She also said, we will change the immigration rules to ensure that the misinterpretation of Article 8 of the ECHR, Right to Family Life, no longer prevents the deportation of people who shouldn't be here. Can you explain what she meant and how it will work and whether it will have that effect?
Well, I think that as to the detail as to how the Home Office intend to change the rules, you must refer to the Home Secretary. I am there to provide the Home Secretary with legal advice, but as you know, one of the features of my role is I'm not allowed to tell you what my legal advice to the Home Secretary might or might not be, or whether indeed I've been asked for it. So there's a strict constitutional rule and I'm tied by it. So one way or the other, I can't comment further. But it is plainly possible, I'll simply say this, it is, the immigration rules can be changed. They can be changed by secondary legislation or they can be changed by primary legislation. That doesn't necessarily make them incompatible with the European Convention of Human Rights or indeed the Human Rights Act in any way at all. And I think the Home Secretary was highlighting, as I understand the matter, the fact that she considered that the rules as they have been drafted, and I think they go back to 2007, appear to facilitate decisions of the type of which she was complaining, where it seemed that the rights to a private and family life were overriding the wider issues about the need to deport people who were undesirable by their presence in this country and who ought to leave.
Dominic, you wanted to come in here?
Yes, I think this is a fantastic announcement. We used to talk, in fact, Joshua, your other half used to talk a lot about this issue, deportation, particularly in relation to Article 3. And sending people back when they might be tortured, terrorist suspects or serious criminals. By far the biggest category of cases, well over 60% of criminals blocking deportation orders are now Article 8. I've got the data on it, and the government deserves great credit for actually putting the civil servants to work producing it. So we're talking a rate of 400 cases a year, people claiming family rights or social ties under Article 8 to defeat a deportation order when they've been convicted of a criminal offence. So that's the data, that's the big picture. The human side of this, I've got a case, this young Nepalese waiter, it's a homicide offence. The perpetrator has got no family ties of a dependency nature. He's an adult. He doesn't need to be there with his parents. He's not got kids himself. He wasn't married. So it seems to me crazy that we can't deport him. We're not talking about sending someone back to be tortured. I wouldn't support that. I believe in the absolute prohibition on torture. In terms of how this can work, and again, the devil will be in the detail, as you know, the Human Rights Act works like this. If you've got a declaration that there's a problem with the law because on human rights ground, if it's secondary legislation, the courts have got a license effectively to say, well, actually, we're going to assume that the interpretation must be done and that the drafters didn't intend to violate the Convention and the Strasbourg case law. They can't operate under that discretion and assumption if it's primary legislation. So it's right that you could change the rules, and by the way, the list of considerations I think is spot on. I think you've probably got to do it by primary legislation. It needs an amendment to the UK Borders Act 2007. But the proposals and the substance are absolutely spot on, and so we're really, I think, talking about the vehicle.
Okay, question at the front and then 2 questions at the back. So first in.
Oh, Brian Wheeler from BBC. Just wanted to ask Dominic if he thinks realistically we're going to see a British Bill of Rights in this Parliament. We've had a lot of talk about delays and trying to accommodate Liberal Democrats. The suggestion seems to be that it's not going to happen, and we're talking about the next Conservative manifesto essentially. Would that be fair?
Well, I don't think it's really a question I can answer. We have a Bill of Rights Commission set up to do this work, and in fairness, notwithstanding the fact that the members of it are drawn from very different strands of view, it's noteworthy that certainly in the advice that they produced to government in respect of how to go about maximising the UK's chairmanship of the Council of Europe, they produced, as I understand, a unanimous view of advice as to what are the priorities in their critique of how the European Court of Human Rights operates. So I think it's premature to say one way or the other what they're going to come up with. We are dependent. The whole reason why the Prime Minister set up the Commission was an acknowledgement that under a coalition government, if we were to make progress in this Parliament, there had to be a degree of common view on what we could take forward.
But the two sides are diametrically opposed. Nick Clegg has said that the Human Rights Act will not be scrapped, and David Cameron says he wants to see it scrapped. So it's hard to see whether there's any common ground between those two positions.
Well, I don't think I can. I don't think I can answer for Nick Clegg. All I could say is that the coalition took a decision, which our coalition partners participated in, that there was value in setting up a Bill of Rights Commission to look at the issues of a possible Bill of Rights. That's what we've got. That is what was agreed by the coalition collectively. That was a desirable thing to do, and that's what the work that is currently being taken forward, including, as I mentioned, by some people who are present in this room. We'll have to wait and see. It's quite an early stage of their work at the moment. We'll have to wait and see what they come up with.
Okay, question at the back.
See, William Salomon, club individual, policy exchange supporter. Just give this slightly off message question. But when I was a lawyer, and when I once tried to use the Human Rights Act to deal with some taxation issues, I discovered that the cohort of lawyers who were involved in human rights pretty universally had a particular political opinion about the world. It wasn't the law that I recognised, which was somehow objective. It was quite a politicised law. So I am always concerned when people think that the law should be used for political objectives. My family have been victims of that in the past, from a different political standpoint, and I rather dislike that. I prefer lawyers to try and see the law as an objective thing. So I wonder whether there is a fundamental problem the way that human rights is interpreted, because the cohort of lawyers that are involved in the human rights business share a particular social point of view. I mean, they were amazed that the tax authorities should be somehow subject to human rights. That was not a group, because they found that very weird. So that was the first question I wanted to ask. And the second question was, what is the relationship between the Human Rights Act and the Equalities Act? And how the Equality Act, in my view, impinges on my human rights, because it's trying to impose on me other people's value judgments, some of which I share, some which I don't share, but I feel I should be free not to. And as I see being counted by my race, by my gender, by my social background, I'm increasingly reminded of why my family left the country they came from and why I see immigrants from Malaysia studying in England, because they're the wrong race. They can't go to university because they don't make up the right numbers in the right quantities. And I am deeply concerned that in an attempt to impose social justice, we will be actually starting a whole new round of discrimination to satisfy somebody else's ideas.
Okay, and lastly, there was one question there from the gentleman back.
Recently trying to Conservative councillor, and two questions, three. Firstly, regarding to right to privacy, for which I think the effect has been quite good, we've effectively got what appears to be judicial legislation, and how do we deal with that? Because that seems to be a very obvious effect of the Human Rights Act. The second question is, Ian Duncan-Smith yesterday said that there would be no to the welfare tourism under the Human Rights Act. If the government doesn't win the appeal, is that a bluff?
Okay.
We're just dealing with Willie Salomon's questions first. I mean, I don't know how long ago that was, but I do think times have changed. It may well be that the impression one gets is that human rights lawyers come drawn from a particular sectional political viewpoint. But my experience is that knowledge of the way the Human Rights Act works is now so ubiquitous across the legal profession that lawyers are very comfortable with using it routinely in litigation, and the idea that you won't find a lawyer who's prepared to take on a tax case on behalf of a taxpayer because he thinks that's a rather odd use of human rights is probably misplaced. I think you'll find plenty of people who actually see that that's a very legitimate area for invoking human rights, because coming back to the point I was making earlier, that is an area of bureaucracy where in fact individual rights are from time to time trampled on, and precisely where in fact a framework of rights can provide good protection. As to the issue of the Equality Act, well, I've said it before, there is undoubtedly an inherent tension within the Equality Act between the different equalities which have to be reconciled. And that too, undoubtedly, has a relationship with the rights in the European Convention of Human Rights. In setting it up under Labour, it was enacted, and I mean, one of the things that we highlighted then, and I've certainly highlighted on many occasions, is that it is going to create issues which will have to be resolved largely through the courts. And I have no doubt that we will see there being greater litigation on this over coming years as these rights are balanced out. There are a number of cases already gone to Strasbourg, wearing of crosses. There is issues about the extent to which freedom of right to conscience can withdraw you from fulfilling your public office, all of which are going to come up for determination. Turning to the issue of privacy, it was quite clear, I have to say, when we enacted the Human Rights Act that we were bringing in the development of privacy law, not sure by the back door, by the front door. We actually debated it. It was one of the issues that was discussed, and indeed that's why a special protection or emphasis on freedom of expression was included in the legislation. So we shouldn't be surprised that Parliament, having enacted such legislation, the judiciary have gone on to interpret it, because that was exactly what the then government intended when it did this legislation. Now the question as to whether we want to have a privacy law of our own which is different is a matter for Parliament. There is scope for it, even within compatibility, I would have thought, with the European Convention. We've often discussed that. Equally, it's probably right, and of course there are various reviews taking place in respect of privacy law, and we will be interesting to see what comes out of that. There is also, I detect from time to time, the slight sense that most people think that the prospect of privacy legislation on its own is a bit of a nightmare when it comes to taking this through Parliament, because of the widely varied views that are likely to be expressed. But that's not a reason why Parliament, if it wishes to do so, shouldn't decide to substitute itself for the way in which the jurisprudence is developing through the HRA if it wants to do it. And as you know, opinion on this issue is very divided, and I think if you go into a room you're likely to come across a wide range of different opinions on the subject. There was one final question on welfare. Yes, it's EU. The welfare law is nothing to do with the European Court of Human Rights. It's a European Court of Justice issue, and what Ian Duncan-Smith is complaining about is creep by the Commission in terms of the way in which it is seeking to impose uniform rules.
Do you want to go in on me?
Yes, I mean, in terms of, just rattle through them very quickly, the culture of lawyers and the judiciary, there's undoubtedly in my mind professional culture wherever you go. I used to work in the Foreign Office, there's a certain culture there, in the city, a certain culture there, and certainly at the bar there is a certain culture. I don't make any rights or wrongs, but I'm surprised it's contentious. And there's a great book by J.G. Griffiths about the politics of the judiciary and about the culture and why they were, and so it was a left-wing book, sort of, they're part of the establishment. Whereas now, sort of 20 years on, they're regarded as part of the sort of fluffy, progressive, liberal left agenda undermining the sort of good old-fashioned, solid British values. So I think and who knows quite how the dynamics of that culture work. I've heard an interesting view from a top barrister who said that don't underestimate the way when the HRA was brought in, the opportunity for judges who were being slammed on civil liberties grounds to take the high ground and be the good guys, at least in the sort of circles that read and enjoy The Guardian or otherwise. Now, I pass that on for what it's worth. On the Equality Act, there is there's nothing wrong with consolidating all the anti-discrimination legislation. I've said it before, keep banging on about this. The extent to which it starts to creep into positive discrimination and social engineering is pernicious, in my view, and should be resisted. On privacy, in judicial legislation, I do think there's been judicial legislation. We know the Max Mosley case, and as Dominic says, people take different views. I think a Bill of Rights would be a good idea to deal directly with this issue as one of the issues we looked at in opposition. And there are two different views on this. And in fact, there are strands along the spectrum, different views along the spectrum in between. You can have the continental view that basically politicians deserve private lives, and what they do in private's got nothing to do with what they do in public office, and the two should be dislocated. And that's how, in my view, you end up with situations like Dominique Strauss-Kahn. Or you can take the view that we have prevailing view that upholds free speech and a free media, that keeps politicians and anyone else in the public eye and holding public positions clean and straight, and if not, there's some transparency and some accountability. And I suspect the Anglo-Saxon, British, American common law tradition errs more towards that. And so I do fear that the way the Human Rights Act operates, and the judicial legislation and the activism will err away from that Anglo-Saxon view to the continental model. I've simplified, but I think there's something in that.
Okay. We are almost out of time, so we can only take one more question and make it brief.
Thank you. Alberto Costa. I'm a dual qualified Scottish and English solicitor working in London and former Treasury solicitor and Department solicitor. We hear the term Anglo-Saxon law, common law, the United Kingdom Human Rights Act, the British Bill of Rights. Recently, the First Minister of Scotland and the Justice Minister of Scotland made some scathing attacks on the competence and legal knowledge of the judiciary within the United Kingdom Supreme Court. Does the panel agree with the comments made by those Scottish ministers? And if not, what proposals do the panel have to ensure that any prospective British Bill of Rights is not simply an Anglo-Saxon or Anglo-centric based legal proposal, but one that is indeed British, taking into account the other legal system of the United Kingdom?
Well, on to the first point, heaven knows I'm on record often enough for criticising the last Labour government for attacking judicial decisions, which I think is a very undesirable thing for a government to do, particularly in intemperate language. And I don't really think that the doctrine of the separation of powers in Scotland is any different from that which we have in the rest of the United Kingdom. For that reason, I always feel rather uneasy when I hear ministers of the Crown in Scotland, the Scottish Government, attacking their own judiciary, because that's what they were doing. It's a matter for them, of course, not for me, but it's not something which commends itself to me as a practice. And I have rather had the impression, having been in Scotland, that there were large numbers of people in Scotland who were also left uneasy by the tone of the language of the First Minister. That seems to me to be the key issue as I see it. Now, on the second point, the UK Bill of Rights has to accommodate devolution. Of course, you're absolutely right, and indeed we highlighted this when we were doing our own work on a Bill of Rights Commission. It raises complex issues, and indeed the Bill of Rights Commission has a Scottish member with Scottish legal experience precisely because of that. I'm not going to, I think, comment further at this stage. I've always acknowledged that a devolution raises some very complex issues, because there's no doubt that the devolved settlements are underpinned by the incorporation of by the European Convention applying in those places.
I mean, I agree with that, and just I think there would be a massive controversy if we said that the British Bill of Rights would straitjacket apply to Scotland without at least some option for the Scottish Parliament or Scottish people to decide whether they want it. It was one of the thorniest issues in opposition, the question of devolution to it. So I think it is difficult. But I cast no aspersions on the great Scottish thinkers of yesteryear who have contributed to the British tradition of liberty.
Okay, I think that's it. We're out of time. I'd like to thank Dominic Grieve and Dominic Raab for their speeches.